Lordship, in item number one, Lordship, may be permitted to appear through virtual mode, Lordship. Lordship, in item number one, I am for the petitioner applicant, Lordship. Lordship, this is an application for extension of time to file the inventory in respect of probate, which was granted on 16th March 2016, Lordship. Lordship, due to the medical emergency of the erstwhile advocate, Lordship, he couldn't prefer any application or any such inventory, Lordship. That's why the inventory was not filed, and for that reason, Lordship, this is an application for extension of time.
Application is already there. Did you file any
Lordship,
application?
Lordship, this is the application G3, Lordship.
Application be,
G3 of 20.
let this application be taken up, okay, on 11th, on 10th of June.
Grateful to your Lordship. Grateful.
2025, appear on 10/6/2025. That's the heading, chamber application.
In this matter, Lordship, I'm the administrator. I was praying for discharge. The department
GS6.
TS1.
Yes, you have filed an application GS6.
Yes, I'll withdraw that also. But I was praying for discharge from this.
GS6 is for what?
It was when I was the administrator. Some work had to be carried on there. For that, I was requesting the parties to give in some money because that the rent receipts were not enough. But then, in any event, now the
Is there any application, pending application?
Yes, application is GS6. That is not, I'm not pressing that. I want to withdraw that. But in this matter, I am the administrator appointed by court.
You can come out with an application
For discharge.
for necessary
Because
discharge.
on the last occasion, Lordship, you were pleased to direct the department to file report whether I have.
Matter was called for.
Yes, I have filed my reports and they had called me.
Report is not there in the.
They had called me for vouching also, my lord, which I had done.
Court. This order was passed on 23rd April. Pursuant to the order dated 23rd April. This is the report on 7th Court. Thereafter, on 23rd April, another direction was issued. Submit a report. It's a communicate finding 23rd April order. Yes, record an order. Learned advocate for the administrator.
I'm the administrator.
Okay. Learned advocate, administrator. What is your name?
Darshana Set.
Is Darshana Set, learned advocate, who is the administrator in this matter, is present in court. Is submitted by the learned advocate. That report is already submitted, and now she seeks discharge. Appears from the order dated 23rd April 2025. Testamentary department of the registry. Directed to submit a report. However, thus, the report is submitted on or before 17/6/2025. Let this matter appear on 17/6/2025.
I'm grateful. I'm appearing for the plaintiff decree holder, my lord. The file, my lord, is untraceable, my lord, in the department, my lord. That's yes, my lord. For
File is before the division bench. I am informed.
not before the division bench, my lord. This is a execution application, my lord, from a decree.
The main file. The main file is before the division bench.
My lord, my lord, we have been told, my lord, that the report has been given that this file is untraceable, my lord. Kindly, my lord, gives a direction.
Let's say file is untraceable.
My lord, the department has.
If I can decree against Eviction.
My lord, appeal has been disposed of, my lord. This only this. My lord, the execution is a separate thing, my lord. It has been disposed of long back.
What is appeal?
Appeal has been disposed of, my lord, long back.
What is the stage of this execution case?
My lord, this is appearing for the first time. That is why, my lord, it did not even run in any before any other court. This is the first time we could not.
Advocate for the decree holder petitioner is present.
Kindly gives opportunity.
Relevant documents are not put up today. Let the relevant papers in connection with this case on or before 16/6/2025. Let this matter appear on 17/6/2025.
My lord, my prayer is for reconstruction of the document, my lord. The file.
The application for reconstruction.
No, my lord, we have not filed, my lord. We have given a link.
It cannot be tested out, that order cannot be passed. So I am issuing another direction to put up the record.
My lord, a report, my lord, also from the register.
The register original cycle. Let us see that the relevant case record is put up on or before the next date fixed.
And my lord, report regarding this file, my lord.
Yes, I have made it clear. This file.
Yes.
This file be put up and the register to see that it is done. 17/6.
It's by substitution application along with the condemnation of delay prayer in the partition suit where I am the plaintiff, Lordship. The defendant two died. One died in 2012, another 2021.
How long is the delay?
4,708 days. Now the suit was dismissed in 2014 because the plaintiff, Lordship, he could not pursue the suit because he became 100% blind. Now that suit has been restored. So kindly come to page 9.
For the first time.
First time, substitution first time. Okay. My suit has been restored by the Honorable Court. Kindly come to page 33. This is order dated 25th November 2024.
Application application.
Suit has been now restored to its original form.
25th November
2024. Now, my lord has already considered the ground of delay because it was dismissed in 2014. Now, after the restoration, we detected that the defendant died.
Which defendant?
1 and 2, Lordship. Shamim Ara Begum and Dr. Javed Iqbal, both husband and wife.
Where is the letter receiving the intimation about that death?
No, we have not received intimation, but we have.
Certificate?
Yes, I have annexed that. Page 39. 39, Lordship. Yeah, 39 is the death certificate of Shamim Ara Begum. She died 2012. And the next page is the death certificate of Dr. Javed Iqbal, her husband.
This is her husband.
Right.
Okay, that is defendant number 2.
He's died on 1st May 2021. Now, during his death, my suit was already
No, this is the page.
page 40.
Page 40 is, this is with regard to, okay, 4/5/2021.
Lordship.
Yes. When did you obtain the information regarding the death?
I mentioned, Lordship, after the registration of my suit
Yes.
in paragraph 13. Suit was issued on 25th November 2024. In January, I came to know. Then I obtained the photostat copy of the death certificate. And paragraph 13, I have also described the legal years of both Asif Iqbal, Shaista Iqbal, and Salma Iqbal. 2 daughters, 1 son.
They have been served.
I have not served, Lordship, because first time it's appearing this matter, Lordship. In the restoration, I have served, but nobody appeared. So this one has not served.
Filing it after the period of limitation.
Naturally, sir. That's true, Lordship.
Let's Permanent advocate for the petition of plaintiff is present. Affected upon the years of his defendant number 1 and 2. Let this matter appear 17/6/2025.
Grateful, Lordship. Much obliged.
Item number 5.
Lordship, in this matter, I appeared for the applicant, my lord.
Your application,
My lord, this was an application for opening a locker of the deceased and handing over the articles. My lord, this was the order passed. The bank has complied with the order. Lordship will kindly come to the second last paragraph. There was an order in terms of prayer C. But this order has been complied with by the bank. So there
Nothing remains.
nothing remains. This can be disposed of.
Yes. Learned advocate for the applicant, executor is present. Submitted by the learned advocate. Appears from the court that order dated 11th March 2025. Branch manager
Branch manager,
of
Punjab.
Punjab National Bank, Chetla branch, was directed to permit the applicant to operate the locker wing number A-173 for causing inventory of the articles. Stop. Terms of the said order dated 11th March 2025. The branch manager, Punjab National Bank, permitted the applicant to operate the said locker and have complied the said order. Nothing remains to be decided in GA 10 of 2025. GA 10 of 2025 stand.
My lord, may I file the affidavit of service?
Affidavit of service filed be kept with the record.
Item number 6.
Yes, not today.
Item number 7.
My lord, 7 to 10 are, my lord, 4 applications. My lord, may I request your lordship to take item number 8 first? These are applications, my lord, really for discharge of caveat.
Yes, item 8.
My lord, kindly takes the, my lord, affidavit. My lord, kindly comes to page 6, my lord. Page 6 is the order. By this order, my lord, the application for, my lord, letters of, my lord, administration were treated to be as contentious cause, directed to be treated as contentious cause. My lord will find that at page 8, my lord, if your lordship kindly comes, the last paragraph. Caveats may be lodged within a week after reopening of the court following the summer vacations. Affidavit in support be filed within 7 days. Upon caveats being lodged and affidavits in support being filed, matter will be treated as a contentious cause and department will immediately allot a testamentary suit number. My lord, I am representing, my lord, the defendant number 1A and 1B in this application.
It is the this is the opposite.
No.
Substituted.
Yes, substituted
Opposite
caveator.
parties.
Substituted caveators. My lord, I am the widow and my lord, the son.
My lord, I appear for the respondent number 6.
Who is my lord?
My lord, appearing for respondent number 6 in this matter, my lord.
So my application is restricted.
You are for 1A, 1B, and 1C.
My lord, there has been a checkered history in the matter. My lord, I would
My
like
lord,
to
this
file
is
an
my
affidavit.
application. If you allow me to just place my application, I would be
No,
grateful.
I'm opposing this application.
My lord, it's my
Yes, your lordship. Yes, your lordship. My
I
lord,
am
I would like to file an affidavit to this
lord,
application, my lord. There has been a checkered history in the matter, which needs to be, my lord.
How will it affect this application? That history? Will it
My lord,
affect?
that will, because there has been a settlement, alleged settlement, which my learned friend is trying to project before this court. But thereafter, my lord, the river has flowed a long way. And my lord,
Executor petitioner?
my lord, may we come back, my lord, may we come back.
executor,
And my lord, in the meantime, if your lordship directs us to file an affidavit.
kindly visualizes
Serve a notice. Let it be taken up in his presence.
in the presence of the executor.
Yes.
I will serve a notice. But he was served. It's master summons. He was served. He is not appearing.
Intimate, it will be taken up after vacation.
Very well.
Okay.
তাহলে সবকটাতেই তাই হবে।
Caveat 1A, 1B, and 1C. Substituted caveat 1A, 1B.
1A and 1B.
1A and 1B.
Yes. In item 8, yes.
Is present. Learned advocate for the
The
opposite.
respondent number 6.
Party number 6 is also present. None appears for the petitioner executor. Thus, the interest of justice, this case stands adjourned till 10/6/2025.
Yes.
Learned advocate, applicant is requested to intimate the learned advocate for the executor by notice.
Very
Your lordship had fixed the matter on 11th of June.
Yes.
Well, very well.
10th of June. 10th of June.
10th of June. 10th of June. Fine.
This order can be, my lord, for
Same order.
same order in.
Okay.
But
same.
defendants are different. He will just indicate the defendants.
Then let me pass an order. 7.
My lord, item number 7 is an application by defendant number 3.
So, please record an order. Learned advocate for defendant number 3 is present. Yes, item number 7, you are appearing.
Yes, I am appearing for 6. Defendant number 6. My lord, in all these matters, I am appearing for defendant number 6. Same cost title, your lordship.
And learned advocate for defendant number 6 are present. None appears for the petitioner executor. Thus, this case stands adjourned till 10/6/2025. Stop. Learned advocate is requested to the learned advocate for the petitioner executor by notice about the next date fixed. Yes,
Very well.
My lord, item number 9 is by defendant number 1C.
Defendant number 1C. Learned advocate for defendant 1C is present. 1C and learned advocate for defendant number 6 are present. None appears for the petitioner executor. Thus, this matter stands adjourned till 10/6/2025. Learned advocate is requested to intimate the learned advocate for the petitioner executor by notice about the next date fixed. Then 10.
My lord, item number 10 is by defendant number 5.
Item number 10, learned advocate for defendant number 5 and defendant number 6 are present. None appears for the petitioner executor. Thus, the case stands adjourned till 10/6/2000. Learned advocate is requested to intimate the learned advocate for the petitioner executed by notice with regard to the next date fixed.
Grateful, my lord.
Deeply obliged, Your Lordship.
Item number 11.
Your Lordship, I am for the petitioner, Your Lordship. This is my execution petition, my lord. This is a suit for eviction, Your Lordship.
This application will be taken up now.
Your Lordship, I'll be pressing for GA5. The other applications are by third parties, my lord.
Lordship, I am for the
Five for
GA5, my lord, what had happened is suit for eviction, my lord. In the decree, there was a direction for appointment of special officer and for calculation of mean profits. Report was given, my lord. On the basis of that, an order has been passed for that report of the special officer with regards to mean profit to be treated as a part of the decree. So now, my lord, we want the execution for the mean profits, your lordship, and we want a direction for disclosure of affidavit of assets.
Lordship, I am led by my senior Mr. Pradeep Mukherjee. Lordship, kindly just passes it over for like 10-15 minutes.
okay, pass over in the first call.
Pass over.
This next.
Item number 12.
Lordship, Mr. Krishnananda Mukherjee is appearing
We are
for
for
the
the degree
commissioner
holder.
of the partition. And he has not been able to come today because there has been a death in
Let
his.
it be not today, let it be taken up after vacation.
My lord, it will be my lord's pleasure to fix it on 10th of June on Tuesday.
Okay, learned advocate for the petitioner degree holder is present. Prayer for time is sought for on behalf of learned advocate for the judgment data.
No. Commissioner. Time is
Commissioner.
Learned, prayer for time is sought for behalf of learned advocate for the commissioner. The matter stands adjourned till 10/6/2020.
Item number 13.
Lordship, in item number 13, I appear on behalf of the degree holder. Lordship, suit for recovery of money lent in advance. A decree was passed in my favor. If your Lordship takes up your Lordship's last order dated 7th of October 2024. In fact, your Lordship had also obtained an order of injunction, but which is unfortunately lapsed now. Lordship, the judgment debtor had appeared and they were directed to file their affidavit of assets. But till date, your Lordship, no affidavit of assets have been filed.
Yes, Your Lordship. I'm from degree holder. I'm led by Mr. Varun Kothari.
It is not appearing today.
Lordship.
Time be granted up to file it after vacation.
Lordship may kindly give a direction on us to serve a notice on the judgment debtor.
Judgment data, yes. Learned advocate for the petitioner degree holder is present. None appears for the judgment data. It appears that by order dated 7th October 2024, there was a direction upon the judgment data to file affidavit of assets. But the degree holder submits that no such affidavit is filed. Let the affidavit of assets be filed on or before 13/6/2025. Let this matter appear on 17/6/2025. Notice the learned advocate for the degree holder is requested to intimate by notice the learned advocate for the judgment data.
Great, Lordship. So may I pray that the injunction order that was earlier granted,
When did that expire?
Lordship, according to the order dated 7th of October, Your Lordship, it expired on the second week of December.
Okay, the interim order granted earlier on, when was it early granted?
Your Lordship, just right before the 7th October order, which I'm right now not handy. If my learned junior can indicate.
Okay.
It was earlier granted on 22nd of August 2024, according to the 7th October order.
Okay. The interim order granted earlier on 22nd August 2024 stands extended for a period of 4 weeks after vacation, 6 weeks after vacation, or till further orders, whichever is earlier.
Grateful, Lordship.
Item number 14.
I appear for the Degree holder.
I am appearing for
The
the
affidavit
judgment
of
that-
assets, your lordship, which my learned friend had submitted on the last occasion is not as per form. So let my learned friend prepare the affidavit of assets as per the form.
Lord, may I file
That's
a
form
supplement?
16A of Annex Appendix E of the CPC. Yes, lordship is aware that if the affidavit of assets is
disclosed all
not as
the
per the form, then the judgment debtor can be arrested also.
Lord, may I file the supplementary affidavit of assets incorporating the bank details, madam?
What have you not incorporated in this?
Apart from the bank details, I have incorporated everything, madam.
Copy bhi hai, sir. You get a copy.
I will serve it
The
within
assets
this.
means all assets, both movable and
Yes,
immovable.
yes, everything is there.
Be as per the form prescribed in the CPC, your lordship.
Yes, learned advocate for
May I
the
file?
degree holder, petitioner, and learned advocate for the judgment debtor are present. It is submitted by the learned advocate for the degree holder that the affidavit of assets is not submitted as per the form provided under the Code of Civil Procedure. Yes. Thus, it may not be accepted. Learned advocate for the judgment debtor pays for time to file a supplementary affidavit disclosing the bank accounts.
Oh my God, that I have already prepared. May I file a supplementary affidavit of assets, including everything in the required form, my lord?
If proper affidavit of assets in the required form.
Required form, my lord.
Learned
The victim and pressing for prayer be, your lordship.
Learned advocate is granted liberty to file the affidavit of assets in the proper form on or before
Early as possible.
13/6/2025. Let this matter appear on 17/6/2025.
In the meantime, the undertaking given by my learned
Yes,
friend
that
to
my
continue,
The undertaking given earlier by
not
the
to dispose
judgment
and
debtor.
alienate the movable as well as
Yes,
immovable.
the undertaking given earlier by the judgment debtor that he shall not alienate his movable and immovable property, the same to continue till further
As
orders.
per proper form order on that. Still warrant বেরোতে পারে। সেটা বলেছি লর্ডশিপ লিবার্টি দিয়েছে।
Lord, kindly record that in default, because this is
My lord.
continuing for 6 months. My lord, I have disclosed everything, my lord. Perhaps it has not been done in accordance with the
Done
law.
it, do it in accordance.
Yes, yes, my lord. The default, the repercussion this should be made aware of. Otherwise, that deliberately this is not being done. Yes, yes, my lord. Our next question is. The Supreme Court gave them time to make payment, they did not make payment. This court extended the time, they still did not make payment. No such order was made, my lord.
Peremptory direction.
Grateful to you.
Item number 15.
I appear for the decree holder, your lordship.
My lord, we are paying whole of the amount to the decree holders.
Oh,
My
yeah.
lord, I'm,
I
Lord,
may indicate
yes, my lord, file my affidavit as to compliance, my lord. I'm
The
filing my
judgment
affidavit as to compliance.
debtors,
And my lord, this is it.
the judgment debtors have filed an affidavit undertaking to pay 33,59,000
What is paid? The matter appeared when on the last occasion?
on
3 weeks
the
ago, probably.
My lord,
weeks ago.
8/5,
8/5.
my lord.
The matter appeared on 8/5. You sought for some time to settle and
to
pay.
settle.
The settlement could not be arrived at, we talked at, so
How
we
much
are,
have you, in the meantime, how much have you paid?
No,
we are paying whole of the amount.
No.
You are paying, but how much have you paid in the meantime?
Meantime, we have not.
your lordship,
Within which date you will be paying?
your
Not
lordship,
today,
by
I'm ready with my demand drafts. I'm ready with my demand drafts, whole of the amount, including the interest.
whole of the amount is.
Yes, 16 and says.
No, your lordship, if you come to pay, if your
paragraph
lordship
number
come to
8.
pay paragraph 8,
My lord.
the judgment debtors are willing to pay 33,59,000 out
No,
of
this is not a terms of settlement. This is the amount which
their
we are going to pay
affidavit.
in course
Yes,
of the day.
yes,
Anyway,
your
I am
lordship.
recording their undertaking and I'll direct the matter to appear whatever is.
Only
What-
one
what you want to
clarification I need, your lordship, if your lordship comes to page 6, where the photocopies of the 2 demand drafts are annexed.
My lord,
Your lordship, the name of the purchaser here in the demand drafts is Master's Collection. So the judgment debtors will indicate what is the relationship between
this
Master's
is their
Collection.
company.
Then your lordship will put a
My lord, put it on record that
put
it
it
is
on
their
record
company.
that the demand draft is being paid on behalf of the judgment debtors, and it
We have put.
Clarified by letter that this is the demand that you clarified by letter.
My
That
lord, I'll, if
with a copy to this said person. Clarify it by letter.
we
with a
have already
copy.
sent a letter, my lord, with stating, I've already sent a
What is
letter.
that letter?
Yes, this is the letter, my lord. I've already sent it.
What is the forwarding letter? Sending
This is the forwarding letter, my lord.
You have not annexed that.
No, there is no letter. This is the forwarding letter for the affidavit of compliance.
Milord, that we, in the affidavit, the demand drafts have been enclosed.
For the judgment data, decree holder, petitioner. The judgment data as present. Learned advocate for the judgment data.
His handling will.
Files an affidavit stating that, stating in paragraph 8 that total amount due to the decree holder up to 31st May 2025 is rupees 33,59,000.
Yes, ma'am.
And not 37
That
lakh
is their allegation.
958.70, which is said by the learned advocate.
And they have also agreed to, the judgment debtors have also agreed to that.
No, I have not agreed. I can
The
come up with the judgments today.
debtors have also recorded in the affidavit that as far as the remaining, the balance amount is concerned, they'll contest the execution proceeding, and they are paying the only part of the amount.
Not part, we are paying with, in my humble submission, we are paying whole of the amount, my lord, but let it be kept open.
958, stop.
33 lakhs 59.
No, that is you are ready. That is your admission with regard to the decree till due.
Me, lord.
And not 30.
Not 30.
In paragraph 8, it is contended that the total amount of due to the decree holder up to 31st May 2025 is not rupees 37,49,958.70.
Your lordship will
This is
come.
disputed by the learned advocate for the decree holder, and it is submitted, and it is contended in the petition that with regard to the balance amount, the judgment debtor will contest the execution.
Yes, your lordship will come to paragraph 10. The judgment debtors intend to contest such wrongful claim of the decree holders and undertake to pay the amount with equity if it is so adjudicated. So they are willing to contest.
Willing to contest and comply if it goes against them.
Yes.
With the facts and circumstances, the judgment debtor is an opportunity to pay the amount which he has admitted in paragraph 8 of the affidavit and have proved the Xerox copy of the, this is a draft,
draft
of the bank draft of ICICI Bank, the decree holder.
However,
however, as his check is not issued by the judgment debtor, but by
their company, by their firm.
But by their firm, it has to be clarified by the judgment debtor in their letter that the same be treated as payment of the decree till debt with a copy to the said company. Let this matter appear on 17/6/2025 for further hearing and orders.
Look, in the meantime, we'll be sending this check today.
Your lordship has perhaps recorded the check is being, this is a demand draft, your lordship.
It's not issued by the judgment debtor, but by their
the
company,
demand draft, yes.
By their
by
firm.
the company.
By
So
their
they have to clarify by
Yes,
their letter that it is with regard to the payment of debt with a copy to the said company.
Yes, I'm just saying instead of check, it will go down as the demand draft.
Yes, demand draft. Check in demand draft.
Great.
So we'll be sending it by the
With a
letter.
letter.
With a letter. Much obliged.
Item number 16.
Item 16. I'm praying for issuance of a warrant of arrest because there has been deliberate non-compliance of my lord's orders for filing affidavit of assets.
My lord, remember this matter, Mr. Shokosachi.
I have not yet completed. My lord, may I
mention just to my
may I show the provisions, my lord, why I am pressing for this? And if your lordship kindly takes a look at first, my lord, order 41, rule 5. There is a money decree today, my lord, which is in excess of, my lord, 3.5 crores. First. Second is, there is no stay. Stay application is disposed of. Specifically recorded, there is no stay. Third, your lordship has been pleased to pass orders directing filing of affidavit of assets. They could have filed the affidavit of assets, but we could not have proceeded with the execution till such time. They have not done so. Your lordship once again.
regarding affidavit
17th of April,
17th of April
2025.
2020.
Yes,
The first time,
that is the first time. Thereafter, your lordship was pleased to extend it once
13th May.
on 13th of May. They have not done so. Day before yesterday, your lordship once again passed an order directing them to file by Thursday. They after that, my lord, at the time of rising or later in the day, my lord, Mr. Shobhushachi Chaudhary, my lord, senior advocate, had sought to mention. Your lordship said come on Thursday. Still today, they have not filed any affidavit of assets. Now, my lord, kindly takes a look at Order 21, Rule 37. But if they do not file, my lord, your lordship would be would kindly, my lord, issue a warrant of arrest, my lord. Kindly takes a look at Order 21, Rule 37. Discretionary power to permit judgment debtor to show cause against detention in prison. Notwithstanding anything in these rules, where an application is for the execution of a decree for the payment of money by the arrest and detention in the civil prison of a judgment debtor who is liable to be arrested in pursuance of the application, the court shall, instead of issuing a warrant for his arrest, issue a notice calling upon him to appear before the court on a day to be specified in the notice and show cause why he should not be committed to civil prison. Now, my lord, your lordship would kindly then look at subsection 2, Rule 2, no, 2137, where appearance is not made in obedience to the court shall, if the decree holder so requires, issue a warrant of arrest for the judgment debtor. Now, kindly sees Rule 41. Kindly sees Rule 41, examination of judgment debtor as to his property. Where a decree is for the payment of money and the decree holder may apply to the court for an order that the judgment debtor, or where the judgment debtor is a corporation, here it's a corporation, any officer thereof, be orally examined as to whether any or what debts are owing to the judgment debtor and whether the judgment debtor has any or and what other property or means of satisfying the decree, and the court may make an order for the attendance and examination of such judgment debtor or officer or other person and for the production of any books or documents. Where a decree for the payment of money has remained unsatisfied, kindly marks this, for a period of 30 days, the court may, on the application of the decree holder and without prejudice to the power under Rule 1, by order require the judgment debtor, or where the judgment debtor is a corporation or any officer thereof, to make an affidavit stating the particulars of the assets of the judgment debtor. In case of disobedience of the order made under Rule 2, the court making the order or any court to which the proceeding is transferred may direct the person disobeying the order to be detained in civil prison for a term not exceeding 3 months, unless before the expiry of such term the court directs his release. But kindly now takes a look at this judgment or order, my lord. Kindly sees, my lord. Since no affidavit of assets has been filed despite earlier directions, this is separate because I'm showing, my lord, for this, that if no affidavit of assets filed, warrant of arrest is issued.
Yes, what is your excuse?
Just 1 second, my lord, before my learned senior friend, my lord, submits. My lord, as on date, there's a money decree which is in excess of 3 crores, my lord, 3.5 crores, and they have not secured any part of that. So, my lord, your lordship would kindly, my lord, appeal is pending, but there is no stay. Stay application disposed of. The GA was filed, but it was disposed of as they did not secure the amount. Not Order 41, Rule 5, your lordship will kindly see. Your lordship has seen it umpteen number of times, but mere filing of an appeal would not amount to a stay when stay specifically disposed of.
Ground for not complying.
I am not saying that I will not comply. Lordship remembers Mr. Chaudhary had mentioned this matter. My clients are in Bombay. I will file my affidavit of assets. I only seek an extension. My lord,
Please record an order.
My lord, your lordship has been pleased to extend it twice, my lord.
Mr. Gupta, learned advocate for the decree holder is present.
But from 17th of April, that
I am
was
judgment
passed,
debtor is represented by advocates. Warrant of arrest is issued when, my lord, they are not represented, they are absconding.
17th April, your lordship has been pleased, 1 month.
Mr. Gupta submits that in spite of granting 2 opportunities to file affidavit of assets are not filed. Stop. Advocate placed that a warrant of arrest be issued in accordance with Order 2141. 3 of it appearing for the judgment debtor submits that he is ready and willing to file the out of station, file the same.
Not out of station. They are, my lord, ordinarily residing in Bombay. That is the reason, my lord. I will file it after vacation.
And sir, are not residents of Calcutta.
Yes, yes.
The affidavit of assets would not be filed. However, justice, the judgment date that granted a half order of assets on or before 13/6/2025. This matter 17/6/2025. This direction is peremptory and no further opportunity will be granted.
I'm very
Sir,
grateful.
kindly
my lord.
mentions in default, my lord, warrant of arrest would be issued.
My lord, I,
No.
peremptory lordship has
Peremptory.
recorded.
And my
Kindly
lord-
seize my conduct.
my
If I
lord- my
don't
lord,
file, I
one-
know the consequences, my lord, in an
One
execution.
prayer, my lord, I would humbly make, my lord, kindly consider, my lord, in the interest of justice, my lord, they should secure.
No, my lord.
No, three
I
and a
am
half
filing
to-
my affidavit of assets.
But I have a decree. My lord, I don't need an interim.
Any interim order, any restraint from alienating the property.
No, kindly passes, kindly restrains their bank accounts, my lord. Kindly restrains their bank account. my lord.
Made that prayer.
Yes, yes, kindly sees the tabular statement. I've made that prayer. Kindly takes a look at, my lord, prayer G. Kindly protects me to that extent, your lordship. Prayer G. Next page, my lord. Next page. At the back. At the back. Next. Yes, my lord, let the bank accounts be attached.
The judgment debtors shall not operate their bank accounts without keeping aside the sum of rupees 3 crore 16 lakh 49,902.
Grateful.
Yes, by 17th you can file.
Yes, my lord, I can. Lordship has given me time till 13th.
13th.
Returnable 17th.
Returnable, sir.
There will be this interim.
Very
Grateful.
I really. With PAN number, sir.
PAN number.
My lord has
And-
specified which bank account because otherwise
No,
it
no.
would.
Your lordship has mentioned bank accounts.
They have not mentioned any.
They have in their affidavit.
But I have also mentioned
My lord,
PAN number because
Kindly
I do
seize, my
not
lord,
know.
their averment in the my lord affidavit.
But that amount, my lord, that account may have no balance.
I really don't
Your
know, my lord.
lordship
He is
kindly-
coming with a prayer, my lord. He is
Kind-
entitled to that prayer, not my lord.
Yes.
Any
then-
other
then
prayer.
kindly gives the full prayer, my lord. Yes. Very well. Very well.
Yes,
Kindly gives the full
operate
prayer.
bank account being numbered. What is the
Any bank account or any account operated under PAN, the PAN number is given.
Very well.
any
So
bank
any
account
Yes.
operated with PAN AACR 4139 capital G. এই যে এটা দেখে ইয়ে করুন।
AAACR 4139G.
Very well.
I'm grateful.
PAN number দিয়ে করেছে।
Item number 13.
ওর জন্য আমি ওটা কেন তোরই সিরিজ
ভুল হয়ে গেছে May it please your lordship,
Yes,
my
I
lord,
can.
I am seeking to execute a decree, my lord, passed on account of mean profit, my lord. Now, my lord, this is appearing for the first time. My lord, I have to serve and come back because this is more than 2 years. But in the meantime, my lord, I am seeking for an order of, in terms of prayer A and B, because of the reason, if your lordship kindly takes, my lord, page 90 for once. My lord, this is the order by which the decree has been confirmed.
Anyway, the defendants have vacated the suit property.
Vacated the suit property. This is only on account of, my lord, mean profit. If your lordship kindly takes, my lord, the decree dated 9 January 2017, your lordship will find that at page 91,
your lordship will find that there is a mention of an immovable property.
It's the amount.
This is 7 crores. If your lordship takes, my lord, this is 7 crores 76 lakh 75,331. This is from the tabular statement.
Because it's a 2-year-old degree.
No, my lord, I'm just placing that.
Sub and come with the
My lord, I'm just placing that. Kindly takes, my lord, page 91 for once. Last paragraph.
Yes.
Mr. Such and such on inquiry put by this court submits on instruction that the substituted defendant is not willing to hand over possession of the flat. The order of injunction passed on such and such in respect of flat number such and such continue till the decree is executed. This immovable property is mentioned in, my lord, paragraph, the first paragraph, my lord, if your lordship takes, the substituted defendant has filed an affidavit wherefrom it appears such and such owned a very valuable flat, such and such, for this. So we are, my lord, trying to attach this property, which was, my lord, put in, my lord, as a security. And there is, my lord, an order of injunction, my lord, in respect of, my lord, this immovable property, and in accordance with this order, my lord, kindly takes, my lord, prayer B was allowed. Under such circumstances, there shall be a decree in terms of prayer B of the petition. So I'm seeking, my lord, to execute this decree, my lord.
It's on page 90.
90, it starts from page 91. The relevant portion, my lord, I placed is at page 91. Yes. And your lordship will find the calculation of the mean profit of the learned advocate commissioner, my lord, is at page 86. It starts from page 83.
2017.
Yes.
We are now in 2025.
Yes.
Okay.
Yes. That is the reason why I said, my lord, I have to, my lord.
What is the difficulty? You serve and come, entire thing will be considered.
But in the meantime, my lord, let this injunction order continue, my lord.
But when was that order granted? Injunction? This is for the
20, yes,
There
2017.
is no injunction. So far this execution case is concerned.
It is there. If your lordship takes, my lord, paragraph, page 91, the last paragraph.
Yes.
The order of injunction passed on such and such in respect of flat number 1F shall continue till the decree is executed. So I just want this, my lord, order to continue.
Decree with regard to the mean profits.
Yes.
Yes. Learned advocate for the decree holder is present. Our learned advocate. As the decree is 2 years old, let this be issued upon the judgment date. And let this matter appear on 19/6/2025.
19 of Probate, Singapore, action.
My
Lord,
the restraint order granted upon the defendant terms of order dated 9 January or order decree and order dated 9 January 2017 passed in A1140 of 2015 connection with CS number 155 of 1995 shall continue as observed in the said order.
Grateful. My lord, instead of 19, my lord, can this be in the month of July? Because I have to serve in Singapore, my lord. One of the judgment debtor is in Singapore.
Okay, 1st July.
1st July.
1st July.
1st July. Grateful.
Item number 11.
Yes, Lord, I appear for one of the applicants in this matter.
The last term.
Yes, Lord.
I'm just telling one thing, Lord. There is a 5 GA filed by the petitioner, Lordship. We have received only 1 GA, Lordship, and without number, Lordship. First, Lordship, they have given a proper GA application.
GA5 has been served only upon the judgment debtor.
You can
Only
see
upon
the
the
list,
judgment debtor.
respondent, Lordship.
Oh, you're the judgment debtor.
Yes, Lordship.
So GA5 is not served upon you.
Yes, Lordship. I have received the only
GA
one GA, Lordship. This is the copy of the GA, Lordship, the without number, Lordship. Let's give it to Judge, sir.
Lord, may I make one submission?
My lord, these are dilatory tactics, my lord. These are absolutely dilatory tactics. Matter has appeared 3-4 times. They have taken time. They couldn't have said all these technical issues. They're only trying to derail the matter. This is absolutely absurd ground for seeking adjournment.
Lord, I appear for one of the applicants in this matter.
And what is the point of saying that there is no number given in the application? It has been served upon them.
Yeah, I received the only one GA, Lordship.
That is the GA5.
GA5, the other GAs are not.
No, Lordship, but we have not received the other GA, Lordship.
Other G, there are no other GA.
Find yourself to GA5.
But Lordship, this is a GA5. How can we understand, Lordship, without the given the without number?
Lord, one in the Lordship will kindly give me one indulgence.
I know, Lordship, this is the 5 GA.
Your Lordship, GA number 5,
them
all
give
the
the
GAs are there in the list. Your Lordship, I'll tell you what has happened. The only new application that has been filed is the GA number 5. All the other applications have been filed by a third party. There are no other applications. So in any event, this is the latest application that has.
Proper post title.
Your Lordship, they could have, it post title has been given, only number is not written there, which they could have said it the third time, or 3 times that they have taken adjournment. They appeared. They appeared, Your Lordship. It is recorded. They have taken time. Mr. Mukherjee appeared the first day. He has taken time. The second day, some junior had appeared, had taken time, and it has been adjourned for the last time. On the third time, he's coming and taking a point. The GA number 5 is not written, so he doesn't know which application.
17th April থেকে appear করেছে।
Appearing from April. Matter has been last heard in May, June of 2024.
Deduction upon the judgment date.
Only for disclosure of affidavit of assets on the basis of mean profits. Nothing
How do
else.
I say now this junction, Lordship? Let them given a proper application of
This
GA,
is
Lordship.
the application, my lord. This cannot be a ground for
Lord,
it.
Lord, may I make one submission? Lord?
Any day after.
You are appearing for?
Lord, I
Lordship given a proper time, Lordship, and the GA number, Lordship, proper.
My lord,
given
3
to me,
times
Lordship.
they were there.
We have
They
taken
had
a
the
proper step,
application.
Lordship.
They saw time. They did not say it on the
Not a-
first day, my lord. Only disclosure of affidavit of assets. No prejudice to them.
Yes.
I'm not even seeking for injunction.
Learned advocate for the judgment dated and learned advocate for the learned advocate for the judgment dated submits that they were confused with regard to the DA application as because no number was given, and learned advocate appearing learned advocate prays for time take necessary instructions. Therefore, adjournment is opposed by learned advocate for the decree holder. It appears from when this matter is appearing, GA5?
GA5 is appearing from 17th of April, your lordship. They were present on all occasions and sought time.
Several opportunities.
But Lordship, in the master summary written the 24th March, Lordship.
Yeah, so thereafter the matter was taken up in April. Mr. Pratip Mukherjee was present on the first day.
Were granted, but no steps were taken by the judgment debtor. However, learned advocate for the decree holder is requested to serve a copy with all necessary particulars and number upon learned advocate for the judgment debtor to take necessary instructions without any fail. Let this matter appear on 10/6/2025.
On the next occasion, your lordship kindly does not allow any adjournment, makes it peremptory, my lord.
Further adjournment.
No, Lordship, they have given a proper document, proper step, Lordship. That is not need to adjournment, Lordship.
Thrice they have taken adjournment, my lord, thrice. And now they're coming and saying there is no GA number written in the application.
Just by letter point it out.
Yes,
They
Lordship.
could have sent this letter before the matter was
they
taken
give
up.
the
This is waste
proper-
of your lordship's time also in
If
the
the
honorable
necessary
court,
to
your
sort
lordship.
the matter before, Lordship, it's a very urgency. So they have given the proper details, Lordship, and proper brief.
If any confusion is
Yes,
there,
Lordship.
get it clarified.
Yes.
Grateful, your
Grateful, Lordship.
Item number 18 to be mentioned.
List. Yes, item 18.
Your Lordship, this is our petition, Your Lordship. If Your Lordship is pleased to kindly take up the last order of 28th of April, Your Lordship had directed another application of ours to also appear today, which is GA number 17.
You are
In fact,
appearing for whom?
For the petitioner, Your Lordship, and we are the interveners.
But I appear for the plaintiff in the suit. This is, my lord, G18 is an application filed by the intervener seeking certain interim protection where in a partition suit.
That is to be disposed of.
That has to be now decided.
And Your
But
Lordship,
there are prior applications, GA14 and 15, taken out at the instance of the plaintiff.
No,
GA
this is
17 is my addition of party application, Your Lordship. That was also directed to appear today, but Your Lordship, it's not
so
appearing.
far this GA18 is concerned, it is an application for
The intervener.
to be impleaded.
No, 17 is, my lord, to be impleaded. GA17.
You are for the plaintiff.
I am for the plaintiff. I am opposing GA17 and GA18. GA17 is the application for impleadment. GA18 is the application for interim orders by the intervener.
17 is also our application, Your Lordship. And the order of 28th of April, Your Lordship, had directed GA17 to also be appearing today. And my interim order, Your Lordship, was extended for 8 weeks or until further order. So perhaps, Your Lordship, my interim order would also require.
5th May 2025. The matter
Lordship,
last
28th April, Your Lordship. 5th May is correction.
5th May is the correction.
That's the correction. And the main order, Your Lordship, is 28th April.
Division bench order ta bolo.
So there are so many applications, 14, 15, 16.
My lord, this is the
17.
Yes, my lord, and 18. My lord,
18 is appearing.
18 is appearing in a partition suit. My lord, GA 14 and 15 is the plaintiff's application for injunction, and order 39 rule 2A is GA 15. GA 16 is defendant number 1's application for recalling of an order. GA my lord 17 and 18 is my learned friend's my lord application.
So let GA 17 and 18 be taken up on the next day.
No, my lord, lordship, I would request my lord GA 14 be taken up first because it is prior in point of time. It is the plaintiff's application.
14 for?
14 is for injunction.
And Lordship, our humble submission.
Anyway, you are protected by an interim order.
He is.
But 17 also, Your Lordship, needs to be heard because I need to be added to the proceedings.
Anyway, but for the time being, you are protected. Let us see.
Lordship.
Defendant number 1, my lord, I am told, my lord, a talks of settlement is going on.
Anyway,
Yes,
we
Your
settle
Lordship.
the matter. I'm just
My
keeping.
lord, I am the plaintiff.
No, if you are agreeable, I can send the matter for mediation.
My lord, it's
Lordship,
failed.
we are agreeable.
It's failed, my lord.
Mediation.
We have tried talks of settlement many a times. It's a
No,
family
that is
dispute.
between two parties. Let it be before the mediator.
My lord, I cannot, my lord, comment upon that without taking instructions. But I took specific instructions today, my lord. There is no settlement going on between the brothers.
And Lordship,
Oh,
we have.
if parties agree, I can send the matter to mediator.
My lord, my client is not agreeable. He wants, my lord, to move the matter. My lord, kindly keeps it after.
Preliminary decree is passed.
No, not yet.
To and the sister in this case, lordship, there is no instructions as of my lord. Kindly keeps after vacation, my lord. My lord, I will take instructions.
Yes,
from
learned advocate for the plaintiff, learned advocate for defendant number 1, and learned advocate for defendant number 2, and learned advocate for the applicant intervener are present. As application for injunction being GA 14 of 2021 is pending for disposal, let GA 14 of 2021 along with GA 17 of 2023 and GA 18 of 2023
my lord, GA 16 also, my lord, this is an application for recalling of one order, my lord.
recalling which order?
My lord.
Okay, GA 16.
Recalling the 2019 order.
And GA, let application for the application being GA 14 of 2021, GA 15 of 2021, GA 16 of 2021, GA 17 of 2021, GA 17 of 2023.
Lordship 21.
21. And GA 18 of 2023
Lordship
must be listed on 10 17/6/2025. As it's submitted by learned advocate for defendant number 1, that talks for settlement are going on. The parties are at liberty to settle the matter in the meantime.
Kindly records my submission that so far as plaintiff is concerned, there is no talks of settlement. That is my specific instruction. Kindly records my submission.
The interveners also saying talks of settlement.
Instructions from our end for settlement.
Lordship, the
Otherwise, my lord, they.
So according to you, there is terms of
It's only
settlement is
defendant
going
number
on.
one.
Lordship, even according to us, we have also sat with them and
My lord, she is the father, he is the son. My lord, they
And
are
my
trying to say, my lord,
instructions are that
settlement. I am the plaintiff, I say no settlement.
As submitted by learned advocate for the defendant number 1, that talks of settlement are going on, which is disputed by learned advocate for the other parties. The parties are at liberty to settle the matter in the meantime. The interim order, which was granted,
My lord, it's extended till 28th of June. It's already there.
It's all
it is
until
further
order.
no
8 weeks for
28th April.
28th April already order says 8 weeks. That is, my lord, up to 28th.
Okay, as the interim order, 28th April 2025 is still continuing. The same is not varied or modified.
My lord, GA16 will also come, my lord.
Yes, all the applications. But 14 will be taken up on the grounds of urgency.
Yes, ma'am.
Lordship, the interim order is continuing, Lordship.
Yes, it is continuing. I have recorded that.
Grateful, Lordship. Grateful.
Item number 19. My lord, I appear under the petitioners, my lord.
Yes.
My lord, service upon the state is not, my lord, complete, my lord. You
Yes.
must kindly take up, my lord, after vacation, my lord.
Okay. Item number 19.
Yes.
On the prayer of learned advocate, the matter stands adjourned till 10/6/2025.
After 11, my lord.
Okay. 17/6/2025.
In the meantime, I shall serve and file a petition.
Service be affected in the meantime.
Item number 20.
Not today.
Item number 21.
For the petition of plaintiff, your lordship. Lord, GA16, your lordship, is my restoration application, my lord. I have served, my lord. This is my affidavit
16
of
is your restoration application.
lordship. My lord, this is my affidavit of service.
Yes. When was the order suit dismissed?
Of April 2024, your lordship, my lord will find that page 41. My lord, this
All the plaintiffs.
my lord. My lord, I have explained, my lord, starting from paragraph number 9, your lordship. Lord, on 2017, the matter was heard, my lord. Thereafter, straightway 2022, it appeared, my lord. My lord, when it appeared, my lord, I was informed.
How many defendants are there?
My lord, 58.
You are representing?
Defendant number 17, your lordship.
17. The other defendants are represented in the suit.
Lordship, they have.
Okay.
Lord, initially,
Which page is the dismissal order?
My lord, at page 41.
41. That is on 16th April 2024.
Lord,
You have taken out this application when?
My lord, in January 25, your lordship, I got to know about this order only in 29th of November
Notice of
2024.
motion. Notice of motion किया Oh. Yes, record an order. Learned advocate for the plaintiff and learned advocate for the defendant number 17.
Lordship, I haven't got the brief yet, and the wakalatnama is also to be filed here.
Anyway, I'll give you the liberty to file the wakalatnama in course of the day. Learned advocate for the plaintiff and learned advocate for the defendant number 17 are present. The application GA16 of 2025 is taken up for consideration. Heard learned advocates. This application is made for recalling the order dated 16th April 2024 passed by this court in CS number 17 of 2011. The petitioner plaintiff have explained the delay in not filing the said application in time. And what is the ground you have stated for not appearing?
My lord,
Which paragraph?
My lord, starting from paragraph 9, my lord, I have explained it. My lord,
Okay, but
2017.
the delay in not filing the application within the period of limitation, and I've
Paragraph
also
12 is more specific.
also furnished sufficient grounds for not appearing when the matter was called on for hearing. Thus, this court is of the view that the order dated 16th April 2024, passed in CS number 17 of 2011, should be recalled. Let there be, after condoning the delay, let there be an order in terms of prayer A and B of the notice of motion dated 20th day of December 2024. 20th of December 2024.
Grateful to your lordship.
GA is allowed. GA stands disposed. Suit is restored.
I'm grateful to your lordships.
Activity matters, item number 22.
Yes, not today.
Item number 23.
Not today.
Item number 24.
Not today.
All suits, item number 25.
I am appearing for the plaintiff.
I am for the defendant number 1, 1B, and 5 to 8.
But today I am pressing, my lord, GA 14 and GA 15.
No, this is not okay.
Uh, 14, 15. Lord, in 1971, the title deed of the suit premises were deposited with one Mridula Singhvi.
Yes.
Now, my lord, this suit was thereafter filed in 1985.
Yes.
For partition and accounts. My lord, Commissioner of Partition was appointed, receiver was also appointed. Thereafter, the same personnel were, my lord, appointed as the receiver as well as the Commissioner of Partition.
So the commissioner cum receiver is a party in the suit or a third?
Now a party. I'm coming into it. The erstwhile receiver, my lord, were creating discrepancies of various natures, including the accounts. I, as a plaintiff, applied for his discharge and with a prayer to, my lord, appoint myself as the receiver in the suit. That was not opposed by any of the parties, except, of course, the erstwhile receiver. He came up with the plea that I am old and infirm now, kindly discharge me. That is a separate issue, my lord. GA 12 and 13, your lordship has been pleased to keep it after vacation. That I will press after when the matter is heard. Here, my lord, after I stepped into the shoes of the receiver, my lord, I found the title deeds missing. Then, my lord, while going through the papers, documents of this suit, that I came to learn about an application filed by this Mridula Singhvi in or about, my lord, 1990s. By that application, Mridula Singhvi sought for intervention in the suit and, my lord, an order of injunction on the Commissioner of Partition, because pursuant to this honorable court's direction, a publication was made for sale of the suit property. That was challenged by this application, seeking an injunction on that publication. Now, your lordship will kindly come to page 87
whereby that application was dismissed by this honorable court. May I place, my lord? This is an order dated 12th January 1998.
Yes.
The application of Mridula Singhvi is summarily rejected. She is by her affidavit ordinary Hazif. She seeks to intervene in this suit on the basis of a deposit of title deed dated such and such. If she has any rights against the land or any other real property, she is well advised to proceed by way of her own suit. And
Yes, I'm rising for 10 minutes. Okay.
Very.
10-15 minutes. Yes.
But I was placing before your lordship, my lord, an order dated 12th January 1998 at page 87. This application was made by that third party with whom the title deeds were deposited for intervention in the suit and for an order of injunction. But the court holds application of Mridula Singhvi is summarily rejected. She is by her affidavit an ordinary Hazif. She seeks to intervene in the suit on the basis of a deposit of title deed dated such and such. If she has any rights against the land or any other real property, she is well advised to proceed by way of her own suit and not disturb the proceeding here. The application of Mridula Singhvi is rejected. It is submitted by the other parties that the suit of Mridula Singhvi would in any event be barred by limitation at this stage, this date. Allegations not admitted by the other appearing parties, stay of operation is refused. But as on 1998 itself, it was barred by limitation. So, my lord, this copy of this application was, my lord, served upon the heirs of Mridula Singhvi, since, my lord, she is no more. After coming to know of this order, my lord, I, as the receiver, issued this letter at page 89 to Mridula Singhvi. How I
Yes.
came to know that she died. After recording all these, my lord, regarding her application and order, I, my lord, called upon her to release or return the original title deeds of the property. My lord, a strange and cryptic reply was received by the receiver at page 96. These, my lord, 5 lines were written on a white piece of paper without any signature, without any date. At page 96, my lord, to whom it may concern, I have no document with me. My mother has expired on such and such. Enclosed, please find death certificate of Mridula Singhvi. So, my lord, it appeared that the heirs of Mridula Singhvi has written this. I found the address of the sender from the envelope.
No, it is addressed by whom?
Addressed apparently by the heirs, because there is no signature, nothing, no name. But the envelope your lordship will get at page.
No, but actually you have addressed a letter to Mridula Singhvi.
Yes, but this is no addressee, no addresser.
But
This is what I have received.
a letter is served upon you.
Letter, yes. Kindly comes to the envelope at page 98.
This is the death certificate of Mridula Singhvi.
Yes.
Page?
That is the next page, 97. And 98 is the envelope. There your lordship will find the addresser and the addressee. It is addressed to Das and Company, the lawyer who had issued the letter, the firm who had issued the letter on behalf of the receiver. And addressed by, strangely, Mridula Singhvi is written, but the letter contains that she is no more.
Now the question is.
Now, my lord, they had appeared. I am coming.
Yes, yes.
Thereafter, I again write to the heirs of the deceased at page 100.
Yes.
There is no response. I file this application. Pursuant to this Honorable Court's direction, I serve a copy on the legal heirs. They appeared. An order is there, my lord, on record. November 20, 2024. Leave was sought to serve copy of the application upon the legal heirs of Mridula Singhvi. And, my lord, on 9th December, when the matter was called on.
Yes.
To the other
legal heirs of Mridula Singhvi.
Yes. I served thereafter.
Yes.
Then on the next date, order November 20 order 9 December. But one Mr. Ajitesh Pandey appeared for Deepak Singhvi and the others who are the legal heirs of the deceased Mridula Singhvi. And, my lord, affidavits were directed to be filed. But till date, no affidavit has been filed. They have not appeared since then.
Now is anybody representing today the heirs of?
No, not even today, and on the earlier occasions also after this date, they have not appeared. Lord, I have
these heirs were represented by this learned advocate.
Yes, and an affidavit direction was passed. No affidavit has come, neither any affidavit has come, nor they are present before your lordship. But I have very innocuous prayers before your lordship. Since the title deeds are not traceable, I have prayed, my lord, that the receiver may be permitted to use the certified copies of the title deeds to be used as original during the sale of the property. That is the first part. Second part is, my lord, there have been directions by this Honorable Court from time to time for publication of sale of this property, since the return of the commissioner says, my lord, that this partition, this property is not partible and the only way out is sale. So, my lord, the publications were issued. Nobody responded to the publications. So, therefore, my lord, my only humble submission before your lordship is, unless a direction for private treaty is granted, this property cannot be sold. It is an encumbered property full of tenants. That is why perhaps, my lord, nobody is interested to purchase. But, my lord, the receiver may endeavor, if your lordship so, my lord, grants the leave. So, my lord, the plaintiff himself is the receiver. And this is, my lord, a partition suit. If the parties do not, my lord, oppose, then, my lord, I would beseech your lordship to pass an order.
All the parties agree.
Yes, your lordship. I am appearing for the defendants, your lordship.
All the defendants.
Defendants 1A, 1B. Yes, your lordship. The issue is this: since it is completely encumbered, hardly will be any party coming up to buy an encumbered property as on date. Your lordship very well appreciates that the hassles one has to go through. So if only there is a private venture that we take, by anybody takes special interest, only then this property can be sold out. And any attempt of public auction, your lordship, will be mere wastage of money on our
It's
part.
already failed. Already
It has
published and
failed. It has failed on previous occasions.
So you have to engage a broker.
Broker, or if there is any acquaintance of any party, of any of the parties who is willing to take this property, and if none of the other defendants object to it, there would not be any problem, I believe.
Lord, these twofold directions I am seeking from your lordship.
Yes, have you prayed to?
Yes, my lord.
To treat the certified copy?
Yes.
Yes, your lordship.
Till that is traced out.
Yes. Page 13, my lord. First prayer is regarding private treaty. Second prayer, prayer B is with my lord, to allow obtain certified copy of the title deeds and to be treated as original. These are the principal prayers.
You are for 1A, 1B, and 1C.
No, your lordship, I am for
1A and
1A, 1B, 5 to 8.
1A, 1B, and 5 to 8.
Yes, your lordship.
Service has been effected on all defendants.
Yes, in notice of motion ta dekhi. Notice of motion ta kothay? Huh? Eta. Yeah.
The only good thing about this matter is there is no discord between the parties in how to dispose of this property, because everyone is busy with their own lives and everybody understands these processes will lead to loss only.
And my lord, the responsibility that I have taken on my shoulders, nobody is willing to take as the party receiver.
Yes, record an order. Learned advocate for the plaintiff receiver, and learned advocate appearing for defendant number 1A, 1B,
and 5
to 8 are present. Heard learned advocates on GA 14 of 2024. It is the contention of the petitioner that the petitioner has come to learn that the following title deeds relating to the suit property was deposited with the said Mridula Singhvi by the predecessor in interest of the parties herein. The said documents, namely original conveyance dated February 25, 1920, original conveyance dated December 15, 1927, and certified copy of the conveyance dated July 20, 1933. Stop. It is further contended that the petitioner came to learn that the aforesaid title deeds were deposited by the parties in exchange of a loan advance to them by Mridula Singhvi for an amount of ₹10,000, which has remained unpaid. Stop. However, no proceedings has been filed by the said Mridula Singhvi or her successor in interest. It is the learned advocate refers to the letter dated January 18, 2024, addressed to the said Mridula Singhvi.
But would it be your lordship's pleasure to record that order by which her application was dismissed?
Yes. By the learned advocates, calling upon her to return all the documents, but subsequently, on inquiry, the learned advocate for the petitioner came to know that the Mridula Singhvi died, and a Xerox copy of the death certificate is annexed to the petition. Learned advocate further draws attention to the copy of the order dated
page 87, Mother.
Yes.
12th
Order
January
dated
1998.
12/1/1998, by which the application filed by Mridula Singhvi to implead as a party in this suit was dismissed. Stop. Learned advocate submits that as sale of the suit property is necessary and the original deeds could not be traced out, liberty be granted to the petitioner to act on the certified copy of the deeds. It is further contended and submitted by the learned advocate as the public auction made earlier failed and no interested buyer turned up, liberty be granted to the parties to enter into a private contract with the interested parties. Thus, upon hearing the learned advocates, this court is of the view that in the interest of justice, the prayer of the petitioner should be allowed. Let there be an order in terms of prayer A, B, and C of the notice of motion dated 20th day of September 2024. Yes, liberty to mention after necessary steps.
Very well.
Let a report be submitted by 30/6/2025. Let this matter appear on 1/7/2000.
But the application remains pending.
The application is disposed, only report of sale.
Report of very good, very.
GA 14.
Lord, may I get some more time?
Anyway, I'm just let GA 14 of 2024 is disposed. ওটাকে আর বলবেন না। ওই যে let it appear on so and so date. Liberty is granted to the party to mention after necessary steps.
Deeply obvious. Okay. Now, my lord, GA 15.
ওটা কেটে দিন ওটা। Yes.
GA 15 is even more innocuous, my lord. I will invite your lordship's attention to page 60, order dated 3rd October 2023, by which the erstwhile receiver was discharged subject to filing of accounts. And my lord, I was appointed as the receiver in his place and stead.
Yes.
But if your lordship kindly sees page 61, third paragraph, this is the relevant portion.
Yes.
Order starts from page 60, page 61, my lord, third paragraph, starting with accordingly.
Yes.
This is the name of the erstwhile receiver. Accordingly, Mr. Such and Such, learned receiver cum commissioner, hereby discharged from his duties in respect of the premises. Sole plaintiff is appointed as the receiver cum commissioner of partition. Plaintiff newly appointed as the learned receiver shall submit a statement of accounts for the such and such period. Erstwhile receiver, Mr. Such and Such, shall hand over all the documents and funds. Now, my lord, the relevant portion. The name of the newly appointed receiver cum commissioner of partition being such and such shall be substituted in the concerned bank accounts. Now, pausing here for a moment, the lordship, my lord, kindly takes the next annexure at page 63. Pursuant to this direction, Lord, I, as the receiver, intimated the bank regarding this order, and after some persuasion, the accounts details of the receiver was changed from the erstwhile receiver to the present receiver. Page 63 is the relevant details of the accounts. Your lordship will kindly see Mr. Hemant Kumar Ved, receiver in the suit. That is the newly appointed receiver. Now, my lord, difficulty is when I received this letter dated 9th April 2024 at page 65.
Yes.
This is the letter received from the advocate of the erstwhile receiver. The bills of the Calcutta Municipal Corporation are still being served on the office of the erstwhile receiver of the suit property. The record is not changed. He intimates me, I, my lord, repeatedly write to the corporation starting from page 66. To the Municipal Commissioner KMC, requested to change. This is my details in terms of this Honorable Court's order. I annex the order. December 2023. Next page, my lord, February 2024. Same letter I issue. Same contention. Kindly change the records. My lord, nothing is being done. From annexure N, page 68, your lordship will find the bills of the KMC raised with respect to the suit premises, not on UC Roy, advocate and receiver, the erstwhile receiver. The office of the erstwhile receiver is still receiving the bills.
No, question is was there any specific order upon the...
That is that order I am seeking before your lordship now.
So that can be obtained from a separate forum, that separate order.
That is why I have, my lord, placed
Or
this
you can
order.
do one thing, you serve them, give a copy.
My lord, what I am beseeching your lordship is, that is why I placed the order of this honorable court, page 60.
Okay,
My lord,
better serve a copy upon the municipal authority and come on the next day.
very well.
But perhaps the municipal authority is not a necessary party or a proper party.
No. So far, this
Partition
application,
But this is a
because they have to give some effect to the records.
But a
So-
direction from your lordship, my lord, will
Yes,
suffice.
but
My
let
lord,
them.
that is why, my lord, I drew your lordship's kind attention to the order dated 3rd October. There, my lord, the bank was not called upon. It is a ministerial change, my lord.
Direction of this.
The records of the
Yes,
bank
where
was
is this
direct.
order?
Page
63.
Page 60 at page 61. The bank was not called upon. The last paragraph, my lord. I am seeking for a similar direction on the Commissioner of Corporation. Only to the extent that the name and details of the
No,
receiver be
question
changed,
is, this is the order of
by
the...
which I was appointed as the receiver.
Yes.
And
So newly appointed receiver come commissioner of partition shall be substituted. All okay.
and the records of the bank was directed to be altered accordingly. Same direction I am seeking, your lordship, with regard to the records of the corporation. A simple ministerial job, my lord.
This is G50. You are representing?
I have defined number 1A, 1B, and 5B.
Yes, record an order. Learned advocate for the petitioner receiver and learned advocate representing defendant number 1A, 1B and defendant number 528 are present, are learned advocates on GA 15 of 2025. The plaintiff, the receiver, has prayed that the name and particulars of the petitioner, namely Hemant Kumar Ved of B127 Salt Lake City Sector 1 Kolkata 7,64,000, being the newly appointed receiver cum commissioner of partition, be directed to be substituted in the books and records of Kolkata Municipal Corporation, place and state of the erstwhile receiver cum commissioner of partition in respect of the suit premises. Stop. And all communications, including bills and or notices, be directed to be issued by the Kolkata Municipal Corporation in the name and address of the present receiver cum commissioner of partition. Stop. It is submitted by the learned advocate by referring to the letters issued by the newly appointed receiver to the Kolkata Municipal Corporation authorities for incorporating the changes, but no steps have been taken thereto. Stop. In the facts and circumstances, this court is of the view that this petition should be allowed. Thus, hence, let there be an order in terms of prayer A and B of the notice of motion dated 8th day of January 2025. GA 15 of 2025 stands disposed. At liberty to mention.
Right. This application stands disposed.
Yes,
Right.
disposed.
Item number 26.
Yes, not today.
Item number 27.
Not today.
Item number 28.
Not today.
Item number 29.
Not today.
Item number 30.
Not today.
Item number 31.
Not today.
Item number 32.
Not today.
Item number 33.
33.
33.
Yes.
Lordship, I'm appearing on behalf of the plaintiff in CS 144.
Yes.
In one of the previous orders, it was directed that CS 144 be listed with CS 228, which is a counter suit filed by the defendant.
Yes. CS 228.
228, Your Lordship.
Yes.
Only CS 144 is listed.
So 228 is to be listed.
Yes, Your Lordship. Along with this.
Okay, item number 33, record an order. Learned advocate for the plaintiff is present. Let this suit appear on 11/6/2025 along with CS 228 of 2014.
Item number 34.
Grateful.
Not today.
Item number 35.
Not today.
Item number 36.
Not today.
Item number 37.
Not today.
Item number 38.
Not today.
Item number 39.
Not today.
Item number 40. Item number
Yes, 40.
And for the plaintiff, Your Lordship. Your Lordship would see the last order. Order dated 18 July 2022.
Yes.
We have paid the stamp duty and the penalty. Thereafter, it was supposed to come up under the heading undefended suit in the year 2022. My prayer would be Your Lordship would keep it for witness action. All the formalities have been completed. Judge's view of documents has also been submitted.
Yes, record an order. Learned advocate for the plaintiff is present. It appears that by order dated 18 July 2022, a direction was issued that the suit be listed for hearing as undefended suit. Stop. A learned advocate for the plaintiff submits that affidavit of documents have already been filed.
Judge's view of documents.
Let this matter appear under the heading witness action on 11/6.
Yes.
11/6/2025. Okay. At 2 p.m. Hey, 11/6 at 2 p.m. আছে কিছু? 3 p.m. 3 p.m. ও আছে। এটা থাক 2 p.m. ই থাক fixed. 2 p.m.
Grateful.
item number 41.
Not today.
Item number 42.
Yes, 42.
42, my lord. On the last occasion, my lord, witness was completed, my lord, and it was to be fixed for orders, my lord.
You are yes.
I am
42.
for the beneficiary. 42.
Okay, okay, let me see. It was, okay, it is, okay, witness was, examination of witness was over.
It's over, my lord. It's a non-contentious case. Witness is over.
Okay,
The
let me
witness
see
has
that.
approved the will and the signature.
देखिए record take two. Yes, record and order. Learned advocate for the petitioner is present. It appears from order dated 13 May 2025 that no further witness will be examined and the matter to be appeared for orders. Stop. However, as the matter is appearing for witness action, let the matter appear under the heading for orders on 13/6/2025.
Yes.
13/6 to appear for orders.
Yes.
লিস্টটা এক্সস্ট হয়ে গেল তাহলে আজকে।